Good morning. I'm Joan Gartland, a longtime consultant with the Institute for Legal Reform, and I have the pleasure of being here with Andy Pincus from Mayor Brown, who has a new paper out today on securities class action lawsuits. Just take a little edge off your, your first discussion. Andy's paper says securities class actions are exploding. It makes the point that more than 8% of American companies will be sued just this year. That's 1 in every 12 companies will be the subject of a securities class action just this year. So let's start out talking about some of the numbers that quantify the situation.
Sure, and I should start out by saying great to be here in another fabulous ILR event. I think if the securities class action system were a patient, we would be sending it to intensive care, because every symptom that you could possibly look at tells you that there's something seriously wrong with what's going on. And Joan, as you say, let's start with the numbers. Filings have gone up to an incredible degree. If you look at what's happened just in the last 5 years, you can see this huge jump from 2016 to 2017, and the numbers tell us that 2018 is going to be another record year, and you can see how much we've jumped over the average. So things have basically doubled in just a few years. That alone tells you that there's something seriously wrong. The numbers are now higher by about 100 lawsuits a year than when Congress acted in the 1990s to pass the Private Securities Litigation Reform Act, because it knew then there was a problem. We've got an even bigger problem now. The numbers tell part of the story. What's really happening here, if you get underneath the numbers, is that we have a bunch of law firms that need inventory. Lawsuits are inventory to law firms who make a business out of these lawsuits. And there are more law firms that want to get into this business, and therefore they're filing more and more lawsuits. As I'm sure we're going to get into, every sort of criterion that we can look at to try to determine are these legitimate suits or are they abusive is telling us that there's real abuse going on.
There's been a real shift in the kinds of securities class action lawsuits, certainly from before PSLRA or since PSLRA, and even in the last 5 years. And you talk about two trends. Can you explain?
Yes. If you go back, and some of us have a lot of history in this area, to the 1990s and what securities class actions traditionally were made up of, traditionally they were about alleged financial irregularities. There were some irregularities in companies' projections, in their audited financials. Lawyers looked at them, they filed a lawsuit. That was sort of the bread and butter of these lawsuits. The percentage of cases that focus on financial issues is much, much lower. Today we've got two new kinds of lawsuits. One group, the biggest group, relate to lawsuits arising out of an announced merger or acquisition, claiming that the disclosures in connection with the deal are somehow not up to snuff. And the other is these event-driven lawsuits. But maybe we should talk first about M&A, because that's really something that just tells you how sick our system is. It would probably surprise most people to know that 85% of deals over $100 million that were announced last year were met by a lawsuit. So unless you think fraud is epidemic in America, that number alone has to tell you that there's something seriously wrong. That trend has been going on for a while, and it used to be, as this chart will show you, that those lawsuits used to be brought almost overwhelmingly in state court, principally in Delaware, because state courts typically deal with questions of fiduciary duty, disclosures, et cetera. The Delaware courts recognized that there was some abuse going on, because what used to happen is the lawsuit would be brought, a settlement would be announced, a few additional disclosures, plus a hefty fee for the plaintiff's lawyers. Those were routinely approved, and so you had a great business going on where file a lawsuit, the company just wants the deal to go forward, it wants to eliminate any possible cloud, it wants to quickly make a deal, and the plaintiff's lawyers get some amount of fees, often $1 million a case when the Delaware litigation was at its peak. So what happened? The Delaware Chancery Court looked at what was going on and cracked down and said, we are not going to approve these settlements anymore that trade some immaterial additional disclosures for a big fee for plaintiffs' lawyers. So if you think you're going to bring those kinds of cases in Delaware, be aware you're not going to have a gravy train at the end. So immediately, the locus of the cases switched. And as you can see from the chart, now most of them are brought in federal court as federal securities cases because the federal courts don't have any such central way of dealing with the cases as Delaware. And so the same process is going on again. Lawsuit filed, some additional disclosures, and here the federal court doesn't even have to approve the settlement under the new gambit that's being used, which is a so-called mootness fee. In exchange for the settlements, there's an out-of-court payment to the plaintiff's lawyers. Again, a huge amount of money being drained out of the system, and a tax really being imposed on almost every deal of any size in America just to get some clarity that that deal can go forward.
The other trend, a little bit a more recent trend, you talked about these event-driven lawsuits, that there's perhaps a lawsuit over the event itself, and then there's another lawsuit, a securities class action lawsuit.
Exactly. So, companies don't like it, but they sometimes have adverse events. Maybe their product becomes the subject of attention from tort lawyers, and there's a deluge of tort litigation, or there's a hack, and some foreign government or bad guy hacks the company's data. So as those events typically give rise to their own lawsuits, as we heard from Lisa this morning. But the plaintiff securities bar had said, well, what if we can piggyback on those lawsuits and file a securities class action alleging that the company misled people about the odds of lawsuits being filed or a hack of their systems. Now, of course, companies typically don't make very concrete statements about those things, so it's hard to actually bring a legitimate securities class action, but it's often possible to piece something together, get that case on file, and then when the company is eager to get the adverse event behind it, piggyback a securities class action settlement on the resolution of the underlying lawsuit. If not, the company says to itself, the bad press from the underlying event is going to continue because we're going to have the securities lawsuit being litigated. We really want to get everything resolved at once. And lots of commentators from Professor John Coffey at Columbia to others have said this is a pretty suspect trend. And again, the reason for it is we have some plaintiffs' law firms that are looking for inventory that just isn't there in legitimate lawsuits, so they're coming up with some new ideas.
You made a sort of interesting point in the paper about a senior securities class action lawyer deciding to get out of the business because it wasn't as profitable for him anymore. Can you explain that?
Well, there was an interesting interview of one of the sort of leading lights of the plaintiffs' bar saying, I'm going to get out of the class action securities business because as I look across the horizon, there just aren't that many legitimate lawsuits to bring, and I don't want to bring lawsuits that are going to be easily dismissed or that I'm just bringing for a small holdup fee. So there you have, from the horse's mouth, as it were, another one of these symptoms that something is really wrong in our system. The other symptom that tells you that something is wrong is when Congress enacted the PSLRA, one of the things it worried about was lawyers being in control of lawsuits rather than actual plaintiffs. And so it created this lead plaintiff mechanism where Congress's hope was that institutional investors would step up and take charge of whether or not a lawsuit could be brought. And so what Congress said is if there's one of the ways we're going to decide who's in control of a securities class action when a number of different lawsuits are filed is to look at who has the largest stake in the case in terms of the number of shares affected. And we're going to make create a presumption that that entity will be the lead plaintiff. The hope was, instead of what was then happening where you had basically pet plaintiffs who owned a couple of shares or 100 shares in a bunch of companies and who could be called on by plaintiffs' lawyers to be plaintiffs whenever there was an adverse event in one of those companies, situation where it was pretty clear the plaintiffs' lawyers controlled the litigation. Congress's goal was, let's put real institutional investors in charge. And so you had a time when pension funds, mostly state and union pension funds, but some pension funds that would step up and put their imprimatur on a lawsuit. The problem with this plaintiff's lawyer noted in his going away interview is they don't want to be associated with most of these lawsuits that are being brought today. So we're back to the world of individual plaintiffs filing dozens of lawsuits, and in the M&A context, literally dozens or 20 or more lawsuits being brought by one person challenging various deals around the country. So again, another symptom that something is seriously awry here.
We talk a lot about meritless lawsuits, but you took a look at the kinds of settlements, the amounts of the settlements in these cases, and make the argument for why there's a rising number of meritless lawsuits going on right now.
Right. Well, one of the problems with that anyone who looks at litigation faces is, since most litigation doesn't get decided on the merits, it's either dismissed or it settles, how do we know whether these cases are meritless or not? There always is a war of anecdotes. The business community will find some true abuses and cite them, and the plaintiff's bar and its allies will often try and find some heartrending story and say, well, this is what these lawsuits are really about. One way of trying to get at what's really going on in the system is to look at what's happening. And here we have an increasing number of dismissals, which tells you that there's very little legal merit to these lawsuits. But even more interesting, the median settlement amount is declining. So when settlements reach the cost of litigating the case on the merits, you can pretty much say, well, we know what the defendant is thinking here. I'm going to have to pay legal fees to litigate on the merits once the case gets past the motion to dismiss stage and the class certification stage. How much is it going to cost me to make this case go away? And if the plaintiff's lawyers are willing to settle for the costs of litigation, that probably tells you that there's not much merit in the case, and that therefore what's going on is a pretty fair trade, a trade that's unfortunate for the system, but understandable to know why it happens, which is the company says, I can get certainty in the end of this litigation for litigation costs that I'm going to pay anyway. Why don't I just pay them and get the case over with rather than paying my lawyer to litigate the case, with the risk, even if it's a small risk, that a judge or a jury may let the case go forward to a very large verdict. So the large number of dismissals and the dropping median settlement number tells you that there's not a lot of merit to the cases that are being brought these days.
You conclude your paper suggesting, or more than suggesting, that it's time for Congress to get involved again to reform some of the abuses that you write about in the paper. You're pretty general in the paper, but what are the broad areas you think that Congress should start looking at?
Well, I think Congress has to look at this through the same lens that it used in the PSLRA and that really guides all kinds of litigation reform. How can we create incentives to bring meritorious cases and not to bring meritless or abusive cases? What can we do to change the system? One of the things we haven't talked about, but has been in the news lately, are questions about whether cases are being brought based on merit or whether there is some underhanded dealing even with some pension funds. As Joan knows, because she's been following it, the State Street case in Boston has been an interesting window into what sometimes goes on in the plaintiff's bar, where a judge found some irregularities in an attorney's fee submission, asked the special master to investigate, and it turned out that the irregularities in the attorney's fee submission, which involved some double counting of contract lawyers, really were little or no of the real problem, and the real problem was that one of the plaintiff's firms had apparently made a deal with a politically connected lawyer to pay that lawyer a percentage of the recovery, even though he did no work, because part of his role apparently was delivering a state pension fund as the lead plaintiff in this lawsuit. So I think one of the things that we have to do is to get more visibility into the underlying arrangements between plaintiffs and other lawyers and the parties who are bringing the case and their lawyers. We should get more visibility at the complaint stage into whether this is someone who, as a plaintiff, who's brought dozens of cases before. Maybe that's something that should make a judge a little suspicious about whether there's merit in the cases. And I think in these M&A cases, we have to be creative about whether there's a way to allow the federal courts to do what the Delaware courts did, which is to say, we're going to crack down on the availability of quick settlements and attorney's fees in order to create a disincentive to bring this litigation in the first place.
I just want to say, if anybody hasn't picked up Andy's paper in the lobby or it's online as well, you really did a great job of pulling together. There's a lot of people writing about this right now. Professor Coffey at Columbia and Kevin Lacroix at the D&O Diary, and a lot of journalists are starting to pick up on the issues that you wrote about.
In the nerdy world of securities litigation, this is actually a huge development, these numbers, because I think one thing to keep in mind, although the numbers of cases don't seem that large, these cases are gigantic. You know, the total settlement numbers last year, I think, were $7.5 billion. So it's a chunk of change.
Okay. Thank you, Andy. Thank you all.
Thank you.